Thank you. Good morning, everybody. Mr. Dramat, thank you very much for coming. Good morning.
Good morning.
You may administer the oath.
Madam Chair, we're calling General Anwar Dramat this morning.
Good. Thank you.
Please state your full names.
Anwar Dramat.
Will you take an oath or affirmation?
I'll take the oath.
Okay, do you swear that the evidence that we shall give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God.
Good morning, General Dramat. You've deposed.
Before you start, Ms. Bauer, General, if you can kindly assist us by speaking into the mic and speaking as loudly as you can, for recording purposes.
Thanks.
Okay.
Thank you.
That's a general with everybody. So I just thought it's the first time you come. We seem sometimes to have problems with the mics picking up. So kindly just speak up and into the mic as much as you can. Thank you.
Thank you.
Morning, General Dramat. You deposed to an affidavit in this matter. Is that correct?
That is so, Madam
And
Chair.
that affidavit is currently before you.
Yes, it is.
Right. Now, I'm just going to take you through a few things in the affidavit, and there's one issue that I would need to highlight. You're currently retired, and you previously bore the rank of Lieutenant General in the South African Police Services. Is that correct?
That's correct.
You were Deputy National Commissioner of SABC, and you were head of the Directorate of Priority Crimes Investigations, known as the Hawks, at the time of your retirement.
That's correct.
Right. Now, you were the person who was effectively, can I say, the commanding officer, or the person to whom Colonel Rulofse reported in respect of the investigations relating to the Mluli matter.
That is correct.
And would it be fair to say that the information you obtained in respect of the Mluli matter is what you largely got from Colonel Rulofse?
That is correct.
Right. You did this affidavit on my request, correct?
That is correct.
And at the time, I showed you a number of letters which you had written to the then acting National Director of Public Prosecutions.
That
Correct.
is so.
You had also previously been interviewed by Justice Zak Yacoub in relation to these matters.
That is correct.
Okay. And I provided you with a recording of that interview.
That is so.
Correct. Right. Now, in your affidavit, you confirmed that at the time it was in your assessment there was a prima facie case against Rigid Mluli in respect of the charges then, but at this juncture your memory can't provide specifics. Is that correct?
That is correct, Madam Chair.
Right. And that your role was one of supporting and supervising the investigating team, then Kobus Rulofse and I think Piet Viljoen initially. Correct?
That is correct.
Right. You recall that you had 2 meetings with Advocate Mrwebi, once at your offices and once at the offices of the NDPP.
That is correct.
Right. Let's take the latter meeting first. That meeting at the offices of the NDPP, you will see, and if I take you to the letters that you had written, that's been provided to you in the pile. Sorry. did I do this one? Give me a second. You will see on the very last letter, which is marked 1345 small a, which would be part of the bundle of documents that we used in the evidence of Advocate Ferreira. But you don't need to go to it for a moment, it's just to refresh your memory. You will see that you refer to a letter which you had sent on the 7th of June, and you refer to a meeting which had taken place on the 1st of August. That's the meeting that you're referring to with the officers of Advocate Jiba at the time.
That is correct.
And you recorded that that meeting sufficiently resolved your concerns, and you have taken note of the shortcomings identified and instructed the investigating officer to obtain evidence. That's what you then wrote off to Advocate Jiba.
That is correct.
Yes, choir master. Right. Now, I specifically raised an allegation that occurred in an explanatory memorandum which had been prepared by Advocate Mrwebi, dated 14 July 2014, and it relates to a paragraph in that where Advocate Mrwebi says, based on my discussions on this matter with General Dramat on 1 April 2012 in his offices in Silverton. Does that sound like the timing of what you can recall as being the first meeting which you had with Advocate Mrwebi?
Just sorry, man, if you could repeat, are you reading from one of the letters?
No, sorry, I'm reading from paragraph 9 of your affidavit.
Okay, sorry.
Sorry, my apologies, General Dramat.
Okay.
He recorded in this memorandum, furthermore, based on my discussions on this matter with General Dramat on 1 April 2012 in his offices in Silverton, does the date of 1 April sound more or less in your memory correct as when you had met with Advocate Mrwebi?
It could be.
Right. It became obvious that at that stage there was no prospects that the investigations against Mluli would proceed any further, as according to General Dramat, the AG who examined the financial statements and issued an audit report in respect of the Secret Service account did not find anything wrong with that account. And my question is, did you relay such information to Advocate Mrwebi at the time?
No, Madam Chair.
Did you relay any information to him in relation to the Auditor General, to the best of your recollection?
No, Madam Chair.
And how can you be so sure that you did not?
First of all, I wouldn't be privy to such information from the Auditor General, that they would have gone through the matters. And also my struggle has always been to have the matter properly investigated. So yeah, that is why I couldn't have said that the matter was found to be in order by another body.
In paragraph 11 is the second allegation of your affidavit, which says, at this point in time, it is a known fact as advised inter alia by General Dramat that the expenses in the account included the transactions which is or are subject of the police investigations were undertaken and assessed in terms of the policies in place, and these were reviewed and audited by the Auditor General and subsequently considered by the JSCI, which I understand to probably be the Joint Standing Committee of Intelligence at Parliament. Correct?
That is correct.
Do you have any recollection of having relayed this information to Advocate Mrwebi?
No, Madam Chair.
Right. And if we look at paragraph 12, that is precisely what you had relayed to Justice Yaqub when he interviewed you in 2015, which is quoted in paragraph 12 of your affidavit.
That is correct, Madam Chair.
Did you at any stage pass on information to him that any of this had been investigated by the Inspector General?
No.
I'm taking you to
Madam Chair.
paragraph 13 of your affidavit.
No.
Okay.
No, Madam Chair.
Okay. Right, now we go back to your correspondence. You had effectively sent off 3 letters. The first on the 23rd of March to Advocate Jiba, which you see there, and which for the record is page 80 of the documents before the inquiry.
Yes,
See that?
Yes, I do, Madam Chair.
And attached to that, you'll see in the second page was the memorandum which was sent by Lieutenant General Makanazi. See that?
You're referring to the document marked 81?
Yes, I am.
Yes.
Okay. And then, if I then, a few pages later, you will see there's a memo which you received from Advocate Mrwebi dated 30th March 2012. Correct?
Yes, correct.
Right. This you would have received just prior to having the meeting with Advocate Mrwebi at his offices.
That would be correct.
Yeah. Is this the letter that would have sparked off you having that meeting? If you look at the second page, it basically ends with saying the decision stands and the matter is closed.
Yes. Yes.
You then address a further letter to Advocate Jiba, which is, you see it's marked 27, which is part of the supporting documents that was part of our bundle for Colonel Rulofse. That is also, if you just move a few pages on, is your letter of the 23rd of April. Correct?
Yes.
You then received a response from the Ms. Jackie Lepinka dated the 4th of May, correct?
That's correct.
And then the following page is a letter you sent off on the 8th of June detailing your correspondence and a request for a review summing up what you had asked, correct?
That's correct.
And then we come back to the letter where we started at, which says, my letter dated 7 June 2012, which is the letter I've just showed you. Correct? It's the last letter.
Yes.
Right.
Yes, that's correct.
And these letters, in your view, reflect what your position was at the time.
That is correct, Madam Chair.
I have no further questions. Thank you.
Thank you, Ms. Bauer. Cross-examination from who is starting? You.
We have no questions for General Kramat.
Thank you, Mr. Masuku. Mr. Rib, your turn.
Thank you, ma'am.
Thank you.
Morning, General.
Good morning.
Just a few small aspects which we'd like to just clarify. In your affidavit that you've been taken through, you've been referred to the memorandum of Advocate Mrwebi, and specifically paragraph 9 of your affidavit, if I could take you back there. And again, in paragraph 11, you record 2 paragraphs out of the memorandum of Advocate Mrwebi. You see that?
Yes, I do.
Okay. Do you also agree with me that
Yes, I do.
do you see that there's no reference there to the Inspector General in either of those paragraphs?
Yes.
So why did you mention the Inspector General in paragraph 13 of your affidavit?
The Inspector General in the correspondence that I saw, there was mention made of the Inspector General.
By Advocate Mrwebi.
No, this correspondence is not by Advocate Mrwebi. No, it's not by Advocate Mrwebi. Yeah.
Can I be?
And
Yes, certainly.
yeah, there's also the correspondence that I had sight of was it's the one marked 106, and it's signed by Advocate Mrwebi, where there is mentioned there's a reference made to the Inspector General's.
I don't know which document you're referring to.
I'm
What's the
referring
date
to
of that document?
the one that is marked page 106.
Yeah.
It's
And for-
correspondence from Advocate Mrwebi to myself. It's dated the 30th of March. In paragraph 3, there's reference the view of the IG following your solicitation of opinion on the NPA decision on the matter based on a document which the police or anybody else were not even legally entitled to process is for your consumption and does not affect the decision taken on the matter.
Yes, but that relates to the letter from the Inspector General that flowed from your correspondence with the Inspector General. Is that not correct? That's a response. Am I not correct?
Just come again, sorry.
That letter that you're referring to from Advocate Mrwebi is a response to a letter that was attached to a letter from you, to which a letter from the Inspector General was next.
That is correct.
So he is referring to, he's referring to the letter of the Inspector General. Is that not correct?
He's referring to my letter dated the 19th of March.
Yes, but to your letter was a response. You attached to your letter a letter from the Inspector General.
Yes.
And in his letter, Advocate Mrwebi is referring to the Inspector General's letter, which is annexed to your correspondence.
He's responding to my correspondence, which includes the letter from the Inspector General.
Yes, so
Yes.
why do you then still, in paragraph 13, what are you trying to achieve by stating that I wish to state that at no time did I ever inform Advocate Mrwebi that the transactions which were the subject matter of the charges have been audited, considered, reviewed, or examined, forget now the Auditor General or the Joint Standing Committee, the Inspector General? Why do you say you never told him that?
Because there was a reference to the Inspector General that the Inspector General would have had sight of this matter.
No, but Advocate Mrwebi, nowhere does Advocate Mrwebi say that the Inspector General audited the figures. What he's responding to is a letter where the Inspector General says this doesn't form part of the Intelligence Committee's purview to investigate, and we're not going to investigate. That's what the letter says that you're referring to.
Just come again, sorry.
General, do you have the letter from the Inspector General that was annexed to your document? Let me let's just cut through the chase, since you don't want to be cooperative. I'm going to put it to you that the only reason you put this statement in here is because you wish to damage the integrity of Advocate Mrwebi. Because nowhere ever does Advocate Mrwebi say in a statement or in a letter that you told him that the Inspector General had audited or reviewed the numbers relating to General or Colonel Mdluli. Nowhere does he say that. So I don't understand why you felt it necessary to put under oath a statement that you did not disclose that to him. And you can answer that if you wish to.
No, I do not wish to attack the integrity of Advocate Mrwebi, but I did not communicate to Advocate Mrwebi that the Inspector General has cleared this matter.
Just in case so there's no confusion, what I'm putting to you is that Advocate Mrwebi does not state anywhere that the Inspector General investigated and cleared the matter.
No, that is so. That is so.
Fine, okay. Then let's go to the other two issues about the Auditor General and the Joint Standing Committee of Intelligence in Parliament. Is it correct that the Auditor General annually does an audit of the, shall we call it, the secret funds of the intelligence corps of the police as a matter of law?
That is correct.
And that report is then sent to the Standing Committee, the Joint Standing Committee of Intelligence in Parliament as a matter of procedure and law?
That is correct, Madam Chair.
And what Advocate Mrwebi will say, and what I'm going to put to you, is that in the meeting on the 1st of April, which he says was a very cordial and quite lengthy meeting, you two had various discussions about various matters not relevant to General Mdluli. Would that be fair and a correct reflection of your meeting on the 1st of April?
It's correct that the meeting, generally all my meetings is cordial. Yeah.
And that discussing...
sorry, I just want to
sorry.
respond because you made a statement about the relating to General Mdluli, which
Yes, sir. And
I'm not sure if you can just repeat that.
Now, I just said, apart from discussing the charges relating to General Mdluli, you also discussed numerous issues irrelevant for this inquiry, just in general discussion about past history and where you people had been in your lives before, etc.
I don't recall such. Sorry.
Are you denying it happened, or can't you
I
recall
don't
it?
recall such.
Cool. Advocate Mrwebi will say that in fact happened. At some stage you were discussing, however, the Mdluli matter, and during that discussion, Advocate Mrwebi will say that in the annual, say that you mentioned in passing, as the two of you were sitting there, that in the annual report of the Auditor General, they did not pick up any irregularities in the account of the intelligence corps of the police, and that is what he's actually referring to. He didn't say that, he's not saying or trying to reflect that you said that the Auditor General had specifically audited Mdluli's transactions. If you understand the difference between the two that I'm trying to put to you. Are you with me on the difference?
I am, yes.
So on the one hand, there's a general statement that there had been an audit of that year, and the Auditor General in its report to the Joint Standing Committee of Parliament had not found any irregularities, as opposed to a suggestion which seems to be the suggestion in your affidavit that Mrwebi is trying to say that the specific transactions of Mdluli had been investigated by the Auditor General. So Advocate Mrwebi will say, in the discussions with you and in talking to you, you in passing said, yes, the Auditor General did not pick up any irregularities during the audit. That is it. What do you say to that?
No, I can't recall.
You can't recall saying it, or you denying that you said it?
No, I deny that I would have said that the Auditor General has cleared the crime intelligence account.
In general?
Yes.
If we had to go back and find that, did they not clear the account for the year when the transactions clearly took place?
I don't know.
Okay. Well, in that respect, that is what Advocate Mrwebi will say, and that's the difference between what your version of the affidavit is and what our understanding is of what the meaning of what it said. You can comment further if you wish to.
I'm not privy to, I don't serve on the Joint Standing Committee of Intelligence, and I'm not privy, and I'm not in the list of recipients of any report from the Auditor General as far as it relates to the Secret Services account of crime intelligence.
No, I think it would have been a matter of public record in any case.
I'm not sure whether the Joint Standing Committee of Intelligence, whether they are public. I'm not sure. Yeah.
Thank you, ma'am. Those are our questions for this witness.
Thank you, Mr. Rep. Any re-examination, Ms.
Just-
Bauer?
Just one question, Advocate Ramat. I consulted with you in this matter, correct?
That's correct.
And I specifically asked you whether there had been any information from the Auditor General, the Inspector General, and the Joint Standing Committee of Intelligence that you imparted to Advocate Mrwebi, correct?
That is so.
And we provided you with a statement.
I've received all these documents that is here before me from you.
Okay, thank you.
Thank you, Ms. Bauer. General Dramat, thank you very much for your assistance, okay?
Thank
And your willingness to come forward. You may stand down.
Thank you.
Thank you.
Madam Chair, could we just adjourn for 5 minutes?
Certainly. We'll adjourn for 5 minutes. Thank you very much. Thank you.
Our next witness. Sorry, I'm just looking for Ms. Manda. Our next witness is Advocate Mokhatla.
Oh, welcome, Ms. Mokhatla.
You would probably need to put the microphone a little bit nearer to you. Maybe move it to the left of the file and talk into the microphone before to do that.
I can try and do that. Am I loud enough? Yes.
If you maintain that pitch, it would be good. Thank you. And try to speak into the mic as much as you can for recording purposes. Thank you.
Sorry, have they already said it?
You want my names?
I have to say you. Have they already done it?
No, not yet.
Please state your full names.
Nomvula Mokhatla,
Will you take an oath or affirmation?
an oath.
Okay. Do you say that the evidence that you shall give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, so help me God.
So help me God.
Ms. Bauer.
Good morning, Advocate Mokhatla.
Morning.
You have prepared an affidavit in this matter, and is that what is before you? Have you got it there?
Yes, I have it. Yes, I have deposed to an affidavit.
Right. And you did so at my request.
Yes, indeed.
And do you confirm that the contents thereof are true and correct?
Yes, as far as I can recall.
Right. Now, I'm going to be taking you through parts of it, and I'm going to not necessarily cover everything in it. Your background, you initially had a B Proc and then an LLB, and you were subsequently admitted to the bar to practice as an advocate.
Yes, that's correct.
You practiced in Johannesburg, Pretoria, Durban. At some point during that, you were an acting magistrate in Pretoria. You subsequently went to the Department of Justice and Constitutional Development as a senior, initially a consultant advocate and then a senior state advocate.
That is correct, Chair.
You have appeared in most High Court divisions and you specialized in civil litigation.
Indeed so.
Right. You were appointed as a Deputy National Director of Public Prosecutions on the 22nd of December 2010, and you commenced employment the following month, 11th January.
That is correct.
Right. And if we, you understood your role to be one governed by Constitution, the National Prosecuting Act, policies, the directives, the codes of conducts, other laws and instructions from the NDPP. Would
Yes,
that be fair?
that is correct, Chairperson.
Right. Now, at the time of your appointment, Advocate Simelane was the NDPP, right?
That is correct.
And you understood that you were being appointed predominantly to deal with civil litigation and civil matters.
That's correct.
You were a year later appointed as the head of the Special Investigating Unit.
Yes.
And shortly thereafter, Advocate Simelane was replaced by Advocate Jiba in a capacity as the acting NDPP.
That is correct.
Right. Now, the SIU operates under different legislation and is appointed differently, correct?
Yes, that is correct.
Right. At the time of your appointment, you were charged to head up the Legal Service Division, and that later became known as the LAD, the Legal Affairs Division.
Correct.
Right. Now, maybe just as a little bit of detail, talk to us about what was the difference in nature of how the LSD operated to the initial ambit of the LAD at the time of your appointment.
Well,
I'm looking specifically at paragraphs 11 and 12 of your affidavit, just so that we can, the presiding officers can keep track of where we're going.
Yes, when I joined the NPA, I found a component called the LSD, Legal Services Division, which was falling under the office of the NDPP. And there was a senior state advocate, senior deputy director of public prosecutions, Advocate Gerard Nel, who was reporting then directly to the NDPP. And what the Legal Services Division would do then would be to coordinate civil suits against the NPA. They will deal with representations, centralizations, and authorizations. There will be what Gerard was doing, which was separate from what the other members of the LSD would be doing, the OECD obligations, the UNCAC obligations. He was representing South Africa in those fora. He would attend meetings, and then he will then produce reports. That division, in respect of that work, he would then work closely with the DPSA as well as DECO. That was not the work of the NPA per se at the time, but then that's what he was doing. Centralizations and authorizations will be done from the LSD. There, he had deputy directors of public prosecutions as well who were reporting to him. One was dealing with the international cooperation and mutual legal assistance, and the other one would be the one that is dealing with the civil suits against the NPA, especially the malicious prosecution matters. And then there was another DDPP, Deputy Director of Public Prosecutions, who was then dealing with the representations. And under these directors of public prosecutions, there will then be senior state advocates and junior state advocates who were assisting in those divisions. Then Gerard, what he will do, he will then, the work of those divisions within the LSD, he will then compile a report for purposes of reporting the activities of the LSD to the NDPP, as well as to the Office of Governance, which we now have as the performance monitoring team, where we lodge our monthly reports. At the time, LSD was working very closely again with the Department of Justice. There in the Department of Justice, there's a division called Law Enforcement. These are legal admin officers in the Office of the Chief Litigation Officer, who would then liaise with the NPA whenever there are any suits against the NPA, and the NPA to provide the requisite information for purposes of briefing the state attorney, and the state attorney to in turn brief counsel if there is an authority to brief counsel. In most cases, as you would recall, before the issue of the involvement of the minister in the affairs of the NPA were settled, in most cases, you would find that NPA is always sued together with the Minister of Justice, would be cited as a respondent. In some cases, will then be cited with the Minister of Safety and Security for, your unlawful arrests, unlawful detention, etc., etc. So, in most cases, you would find that NPA is cited together with the, the three parties. So, in cases where NPA is only the respondent, then NPA will then deal, with the matter without consulting with any of the departments, and especially with the question of briefing counsel, then NPA will then, together with the state attorney, talk about who to brief for that purpose of handling the matters on their behalf.
So in respect of the LAD, when you came in, it was decided that the LAD would initially deal with anything legal other than prosecutions, and later that changed to exclude labor.
Indeed, that is so.
Right. And you would also work closely with the NDPP in providing legal advice on various aspects and litigation support.
That is
Correct?
so.
And in paragraph 13, you listed what wasn't a closed list, but some of the more specific stuff that the LAD at that time was involved in.
Yes, Chairperson.
Correct? And let me just take the first item, which deals with representations to the NDPP. That will be pursuant to the powers which the NDPP has in the Constitution to intervene or review matters. That would initially have come to the to LAD.
Yes, that will be so.
Right. Okay, so in paragraph 14 and 15, specifically you deal with the staff complement that existed at the LSD initially, with an amalgamation of a number of smaller units into LAD. And you point out that there was at least initially 8 deputy directors that was in LAD at the time. Correct?
Yes, and that was created by the amalgamation of the other business components within the office of the NDPP.
Right. And in paragraph 15, you recalled one of the incidences or one of the advices which was sought very early on when you were there, and that was the role of the DPPs versus the role of the NDPP.
That is correct.
And maybe just elaborate on that.
Well, at the time, there was there were 2 proposed structures, where the one structure would have the DPPs reporting directly to the NDPP. And I do remember that there was a memo that was circulated, which we individually discussed with the then NDPP advocate Simelane. And at some point, I do remember having discussed it with advocate Jiba, especially, you know, the issue of the NDPP being the direct line for the DPPs to report to. But then that issue was quickly settled, that it's best if we have a DNDPP as a buffer between the DPPs and the NDPP, precisely because of the constitutional obligations that the office of the NDPP have to discharge in respect of review of matters.
Okay, and thinking behind that was you would effectively be protecting the original decision-making powers of a DPP vis-a-vis the original decision-making powers of the NDPP on a review of a DPP.
Indeed, that's precisely what I'm
Now,
saying, yes.
One of the structural changes that came about was that, under Advocate Jiba, was that the strategy and operations unit, which in fact I think she headed before becoming acting NDPP, became one called National Prosecuting Service, with Toko Majakweni as its head in the capacity as an acting DNDPP, correct?
Yes, that's correct.
Right, and that resulted in a reduction of the mandate of LAD, as a number of matters were then transferred over to the NPS.
Yes, some services were then transferred to NPS, and because those services were, I'm lacking the English word now. I don't want to say discharged, but the people who were rendering those services moved to NPS together with those services. Because then, you know, in terms of us doing the work, we would have a component that is dealing with, say, representation. So all those people who deal with representations will then move to NPS with the representations.
Okay, so the effect of that meant that the LAD was significantly reduced, both in staffing, hierarchy, and workload.
Indeed.
Right. And then you recall a meeting that was held at St. George's in early 2012, which, if I look back, was probably a meeting which involved the extended EXCO, DPPs, DNDPPs, CEOs, etc.
Yes, yes, that's
strategic
correct.
meeting is the word I'm looking for.
Well, it was an EXCO meeting.
Was it EXCO meeting?
Yeah.
Right, and at that meeting, the issue of the structure of the NPA was being revisited, because the question came up as to whether Advocate Simelane had actually obtained approval from the Justice Department when he had made changes to the structure.
Indeed.
Correct?
Yes.
And one of the issues that came up was a debate about how lawful the establishment of LAD actually was. Correct?
Indeed, that is a subject that was discussed at the meeting.
Right, and you were meant to do a presentation that never materialized, correct?
Yes, it never got to that. I think around about mid-morning, I was then told that there would not be any need for LAD to present.
Right, and it wasn't the position then at that juncture that LAD was used by all the DPP officers for purposes of rendering assistance with civil litigation, correct?
Yes, correct.
Right. And what was then left within LAD?
The civil litigation, the mutual cooperation, international cooperation and mutual legal assistance, OECD, UNCAC, through Gerard. What else? Let me check if I'm not missing something. It's
I
a
think
very
that's-
long list.
That's the list that you...
It's a very long list. Is that my paragraph 13?
Well, after the reduction in LAD, some of these tasks in paragraph 13 went to NPS, as I understand it, and you, let me just see in which paragraph you mentioned this. Paragraph 23.
Yes, I think I've mentioned that because then then of course legal advice to the office of the NDPP, opinions, etc.
And you would continue to vet the contracts for service level agreements in
Yes,
the NPA.
vetting of contracts as well.
Right. And your approach within LAD was that effectively you held weekly meetings with your personnel and you would discuss problematic areas and case strategy.
Yes, including our whereabouts, what is on the table, what is likely to impact on us, because we were a few, a few numbers, so we needed to manage the work accordingly and check who's going to be on leave for when, and look at what matters would be on the roll for those dates, so that people can either be on standby or still please be on duty. You'll take your leave afterwards.
Right, and you mentioned weekly meetings both at paragraph 20 and at 29, so let's deal with them together.
Okay.
You use those meetings for purposes of keeping abreast of what's going on in the unit, correct?
Indeed, it was important that I do that.
Right, and you mentioned an allocations book. What is that?
Well, when matters come through to LAD, then there would be a place where we record whatever case has come in, allocate it a reference number, and book it out to an LAD official. So at the time, we're using a manual system where, you'll just go to the book. But then on the side, we're also developing an electronic system where we would record everything in relation to the case. The milestones of the case, we will then, record it there. And I remember at some point we asked for an electronic system, but then, because of the lack of money, that was not approved, eventually, but we had to make do with what we could make do with. But then that book, as well as what we've created as an Excel spreadsheet, just to keep abreast as to who has been allocated at matter, when did the matter come in, what is the reference number, if there is a case number, who is the state attorney dealing with the matter. So that was recorded in that book.
Right, and if something was not allocated to LAD, would it not be recorded?
We would not have it, obviously.
And did you find that there were civil litigation matters that were not allocated to LAD?
Indeed.
Right. And how did you discover this?
You would at sometimes get wind of it when there is a warrant of execution, for instance, and the CFO would be, at pains trying to establish as to what happened, should they pay, and, going back when we do our research, then you will find this is an old matter that emanates from a particular DPP office, and then in the DPP office, there would then be someone perhaps who would coordinate the receipt of the summons, etc., or deal with the state attorney directly. So it's only at that time that we would pick up that this matter was either not properly dealt with by the state attorney, or it was just not given any attention, or there's no record whatsoever that the matter was dealt with by the state attorney. So we'd pick up at that stage, would pick up at a point where maybe there's a notice of bar, we find there's a notice of ban, then we try to establish, but where is this matter? We look for it in our records, and if we don't find it, we try and make, and do more research and liaise with the state attorney, liaise with the law enforcement office to find out what has happened with the matter, and then try and deal with it from that point.
Now, if the matter was not allocated to LAD and it wasn't necessarily in the allocations book and it wasn't raised with you at any of the meetings and it didn't come to your attention in any particular way, then you would actually not know about it.
Of course, I would not know anything about it.
There are, as I understand, matters that wouldn't have been allocated to LAD, but on which your advice may well have been sought separately, and you would then become aware of those matters. Correct?
Yes, yes.
And just so that no one is misunderstanding, the conversation we're having now relates solely to civil matters, which involves either the NDPP or the NPA. Correct?
Oh, there's a difference now. We were dealing with those matters very differently, where the NDPP has been cited.
Well, let's come to the NDPP
Okay.
matters in
Later.
a bit, yeah.
Okay.
Let's deal with that, right? But let me rephrase it. We're talking about civil matters, not prosecution matters. That's the,
Only civil matters.
Right.
We had no mandate whatsoever to deal with prosecutions.
okay. At the time, you were and the state attorney was effectively the attorney of record for for these matters, correct?
Yes.
And there would be an arrangement with the state attorney on the briefing of counsel,
Yes.
right? In certain high-profile matters, where would the choice of counsel lie?
It will depend if it emanates from a particular business unit and the issues that are involved in the matter require a particular counsel. They would also make a recommendation, which recommendation then we will also table it in front of the NDPP, and then approval will necessitate the signature then of the CEO, and that particular choice of counsel will then, be approved. But there are some cases where we would feel that we need to have representativity. We will liaise with the state attorneys and then find out in the region where they are. If it's Eastern Cape, find out from the state attorney if there is someone with the requisite expertise to deal with the matter, and then we will take that recommendation. However, we'll also place that recommendation in front of the NDPP, and then we'll all agree that, okay, this is the council that we need to brief.
Okay. You also had attended weekly meetings, which I understand from previous witnesses was instituted by Advocate Jiba, where there was I think it's a Monday meeting between the DPPs and her, correct?
Yes, we would have the Monday meetings.
And those would deal with what?
We will talk generally about the areas of where we are responsible, the portfolios where we are responsible, any things that we need to put in front of the NDPP which are urgent in nature or which require other members of EXCO to make an input into. We will talk about those things, the running of the NPA, the budget, etc. The CEO was also part of those meetings.
Now, when it came to the task of LAD, as far as you can recall, what was its role in relation to the compilation of Rule 53 records?
Well, in a normal sense, because you are dealing with civil litigation, if there's anything that is required, you need to render your assistance through and through with all the processes. So if a matter requires that there should be a Rule 53 record filed, then LAD would necessarily have to do that and file the Rule 53 record. But then your brief will then also indicate as to whether you are now briefed to compile a Rule 53 record or what is it that you have to do. But if you have been charged with a matter from inception, and then you are given instructions that here is a matter, here's a file, deal with it for me, and then all the necessary steps, anything that comes into the matter, you will have to do that and comply with what needs to be complied with.
And the contents of a Rule 53 record you would have to be provided with by the decision makers who are the subject of that review.
Of course, information will then be sought from the relevant parties or relevant officers for purposes of compiling a Rule 53 record.
As a norm, was high-profile matters discussed at these weekly meetings with Advocate Jiba?
We would not go into detail as to what is exactly in the high-profile matter. So high-profile matters would be classified as those matters which first have attracted a lot of media flavor, lack of better words. But then, you know, there are those priority cases, you know, the corruption cases. If there's a problem that needs to be, you know, untangled, we will then, you know, maybe talk about that at EXCO. It was not necessarily to discuss the merits of the cases. I remember there was a matter which was already, you know, settled by NPA, but then the lack of better words, I would say the suspect was then arrested in another country. And then when there was supposed to be a repatriation of funds from that country, him having been convicted there, he then interdicted us from receiving the funds. And I raised that, you know, at EXCO that there is this application that is before me. And then we talked about that.
So in paragraph 31, you deal with the ordinary procedures for the management of civil cases within the NPA, where court documents are served on you, and you then point out in respect of court documents where the NDPP is cited, and tell us about how that differs.
Well, matters where the NDPP is cited, they necessarily have to have her attention or his attention. There is no way that a matter can be dealt with without involving the NDPP, more especially if it is about what the NDPP has done or not done. So all matters where the NDPP is cited will then be sitting in the office of the NDPP, and the NDPP will then decide whether he or she wants to employ outside counsel, or you deal with the matter, or what the instructions are. So it can never be dealt with without the knowledge of the NDPP.
And is it so that those matters are always referred to LAD?
Not always.
But there were times that matters were referred to LAD by the
Indeed.
NDPP office.
Indeed.
Right. And this would be the prerogative of the NDPP.
Yes.
Right. Now, we'll come back to the Boyson matter, but the Boyson matter is one of the matters which you say was not referred to LAD.
No, we didn't deal with the matter.
Now, you at the time were dividing your time between LAD and SIU, correct?
Yes.
And you put procedures in place in relation to LAD matters when you were at the SIU offices.
Yes, I did that.
And you, in fact, had a consultation with Advocate Jiba in respect of what those processes would be, correct?
Yes, indeed.
And what were they?
Well, because I'm going to be away, I needed to have a person that I can, you know, trust in terms of the experience that the person has to be there for the NDPP in my absence, especially when these matters come to the NDPP's table where the NDPP is cited. So we then agreed with Advocate Jiba that Mr. Tobile Krita will then be the perfect person to liaise with in my absence. And thereafter, Mr. Krita would then be the one who informs me as to what matters are on the table, what needs to be done, and etc.
And in fact, we'll come to this later, but he's the one that brought the full matter to your attention, the freedom under the law application, which we'll discuss in more detail later. Right?
Yes.
And that was one of the matters that came up in your absence, which Mr. Cheetah then dealt with. Correct?
Yes, yes.
So if we take you to paragraph 35 of your affidavit, you draw a distinction between matters which is dealt with by LAD at its outset and your role as head of LAD in that instance. And you say that where it is not dealt with by LAD, then you have a lesser participation in that matter. Is that so?
Indeed.
As far as the attendance of yourself at consultations with council, what was the position?
Apart from my participation with council,
No, sorry. What was your approach when it came to the attendance at consultations with council on matters that came to your attention?
well, I will try to meet almost all that I feel are important consultations with council. However, because strategies will then be dealt with, we'll have a case plan as to how the case should be dealt with. Some consultations I would not see any need to, consult, but I would need to know that there is a consultation for me to go and attend. If I don't know about the consultation, I wouldn't even, I wouldn't know about it, so I would not attend it.
And
And then it will also depend on the brief that I've been given. LAD, the Legal Affairs Division, was working on brief. We did not go out to seek out cases. You would receive a brief, and in the brief, your client, in quotes, your client would say, this is what I would like you to do for me. Please advise on maybe a particular section, please advise on this one. Has there been compliance if somebody is asking for that? Would you please assist us with a review application? It depends on the brief. So whatever the brief requires you to do, you will then do.
in paragraph 36, you point out what your instructions were to those people in LAD and you needing to be kept apprised of all the matters that they were dealing with, correct?
That is indeed so, and that was the reason why we're having those not Monday, I think we were having them on Fridays. We're having those weekly meetings where everybody will be kept, abreast as to what is happening, and we'll all sit as the Legal Affairs Division component. All of us will sit there and talk about the work that we are doing, and obviously the reports that will then come out, not every matter will then be discussed in those meetings, but then in the monthly reports, we will have a list of all the cases that have been dealt with, what is outstanding, how big is the role, for lack of better words.
Now, when it comes to complaints against members in the NPA, those would not come to LAD, those would be dealt with by the office where that member reported to, correct?
Yes.
And those matters would only come to you if your involvement was specifically sought to give advice.
Indeed.
Right. What would the position be in respect of letters that go out from the NDPP in those matters? Would they automatically come through LAD?
Not necessarily, to depend what is an issue in the letter, but when we're dealing with the representations, then all that information that will be sought even from the DPP, the decision that has been arrived at, and look at the case, go through the docket, go through some correspondence, internal memos, etc., and then you will then compile a memo that you will present to the NDPP together with a draft letter. Sometimes we'll do 2 letters. If you agree, if you don't agree, we'll have that. But then in the memo itself, we would be putting all of those things, for the NDPP, look out for this one, look out for that one, in that file, this and that, this and that. But then ultimately the NDPP will have to apply his or her mind to the file and see whether or not they agree or they don't agree with the decision of the DPP.
Now, in relation to the matter dealing with Advocate Breitenbach, you did not have any involvement in that matter. Your advice wasn't sought in either the labor matter, the disciplinary inquiry, or the criminal proceedings. Is that correct?
Yes, they don't fall within my mandate.
And you are aware that Mr. Chita was part of an investigation team that had been appointed?
Yes, he was asked, so I provided a resource because we are all, government employees. So if somebody is asking you, would you please give me somebody to work with me on this one? You ask the individual, would you be amenable to doing it? What's your workload? And then if they agree, then you simply say to your counterpart, it's fine, you can utilize him. But then because it's not something that is within my mandate, I would not follow it. I would not even supervise the work that is done there.
Right, now, I want to, you in paragraph 43 make a general proposition that decisions taken are ultimately taken by the NDPP. And where it is matters which directly impact on the office of the NDPP, those Advocate Jiba dealt with by herself. Correct?
Can I hear you again?
Paragraph 43,
Yes?
where the matters ultimately lay with the NDPP and decisions were taken by the NDPP, those were coordinated by Advocate Jiba. I'm phrasing it badly. So let me try this again. I'm trying to not lead you much, and you did not necessarily deal with all matters of a civil nature.
Yes.
Correct. In relation to civil matters, where the NDPP was cited or involved, those matters lay for final decision within the NDPP office.
Okay, yes, in terms of being given advice or etc. So it will be up to the NDPP if they take or they don't take the advice.
Now, in relation to Advocate Jiba, in respect of those cases, she coordinated things herself.
It seems so from the attachments that were shown to me.
Now, when we come to the full case specifically, right? You had, your evidence is that you had a very limited involvement in the full case,
Yes.
right? And I want to take you through that from paragraph 44 of your affidavit. As you already indicated, it was one of those matters that was served when you were not at the LAD office. Mr. Chita informed you of it, and he directly realized with Advocate Jiba to get instructions. Correct?
Well, in that regard, I was not in the office, but then he phoned me to say that there is a matter that has arrived. It is this way. But because obviously in the normal course, as we have agreed that Mr. Chita will be the one who is assisting the NDPP directly, so in my absence, it would have seemed proper for him to do that.
Right. You then liaised with him to deal with the matter, and you had a discussion with him about the way forward on the matter. You recall he provided you with a copy of the founding papers.
I'm not sure whether he brought them to me or I went to NPA. So what used to happen would be I would have half a day this side or another day and almost the whole night in the one office. So I would try and not spend a day or two outside of either one of the offices. So perhaps I found it on my desk, or maybe he brought it to me at SIU. I don't remember how the founding papers were brought to me. But when I was called that this matter has arrived, and I asked, but is there anything on the NDPP's desk? Because from from hearing about the matter, it was my sentiment already at the time that this matter should not even be, a matter where the NDPP has been cited, because what was then complained about was the decision of the DPP and the decision of the special director, which had nothing to do with the NDPP. So I already took that stance before even seeing the papers. So that's what we talked about with Chita.
Right, and you weren't party to any conversations directly with Advocate Jiba at that juncture?
No, I don't think that I
Right.
involved her in that at that time.
Okay, so what then Sorry, I'm messing up my own papers here. Right. At that stage, you were not aware of a memorandum that had been prepared by advocates Breitenbach and Ferreira.
Nope.
Okay. We at the inquiry had been provided with a copy of that memorandum. Your name appears in the address list, and the evidence before this inquiry was that Advocate Ferreira and Advocate Breitenbach intended to deliver this to Advocate Jiba and all the deputies, and that when they got to Advocate Mrwebi's office, he indicated to them it wasn't necessary. He would provide you with a copy thereof. Were you ever so provided with a copy?
No, I wasn't. And in fact, I wouldn't even be expecting any memos that emanate from the conduct of prosecutions unless there was an issue raised which somebody wanted me to deal with. It would seem odd that I would be a co-recipient of such memos.
Right. Now, you, after the full matter landed, you recalled having a conversation with Advocate Mrwebi about the matter.
Yes, but I don't remember as to what time, but it was soon after the matter was served, on NPA.
And can you remember the gist of that conversation?
Well, as I said, my initial stance was this is not supposed to include the NDPP. And then when I spoke to Advocate Mrwebi, I don't know if, I can't say this word was said or this word was not said, but the gist of the conversation was that Glynis Breitenbach was given a task to fulfill, to go and look for the evidence that is being sought so that the matter can be enrolled. The matter was provisionally withdrawn because it was not ripe for trial. So instead of Glynis Breitenbach coming back with the required information, then the FUL, the application then came to be served on NPA, which is something that I also frowned upon, that how can an outside body get into the business of NPA, because we are working here. The special director has asked for further information, which is done in the normal course of a case, and yet instead here is an application for FUL being served. At that time, it was after the FUL application had been served on us. But in my mind, as I was conversing with Advocate Mrwebi, it felt like it's something that has just happened. That instead of the evidence coming back, then the application is served on NPA.
So at that stage, you didn't know that the meeting with Advocate Breitenbach, to which he referred to, had already happened 5 months prior thereto?
I had no idea.
And at that juncture, did you know that he had indeed written a letter to the Mr. Mluli's attorneys indicating that the matter had been withdrawn?
No, I didn't know at that time.
Right. You recall that you then inquired from Advocate Jiba if there were any representations emanating from the Luli matter. Tell us about that.
Yes, I asked that, one, because LAD was no longer dealing with representations, and obviously, if there was any, it would not have been served on us, but on NPS. But then I asked Advocate Jiba, because she's the one who would have received any such correspondence from NPS or maybe even NSSD. But then she answered positively that there isn't any representation that has been served on her table, and that gave me the confidence and the assurance, and we discussed the strategy around the case that, look, she should not be involved in this thing.
And that effectively, as I understand it, informed your approach that she shouldn't be involved in filing the main affidavit, and that the decision that had been taken by Advocate Mrwebi and Advocate Chauki, they should be the main deponents, with Advocate Jiba's affidavit being a minor affidavit for lack of a
Yes,
better word.
Because the NDPP was already cited and we did not go through the applications of having the NDPP removed from the case itself. So there it was. So the most prudent thing that we could do at the time, that I felt, even now I still feel we should have proceeded with it that way, that the NDPP would only talk about process and prosecution policy, and then let the people who have made those decisions be the ones who depose to what they have done. More so because the matter was not in the NDPP's office in respect of any other party coming to the NDPP making representations, or that the NDPP has been asked to review the decision of the DPP or even the special director in the Ndluli matter. Yes.
In fact, what then transpired was there was a letter that was sent to the applicants indicating to them that their attack in this regard was premature.
Indeed. It's against the NDPP. In fact, in respect of the whole matter, because then you need to afford the NDPP an opportunity to deal with the matter. Why do you go to a court of law when you have, in terms of the law, a body which is, even the office of the NDPP created by the Constitution to deal with such matters? So yes, that's the reason why the letter went out.
Now, as far as the Rule 53 record was concerned, as far as you were concerned, the NDPP had no involvement because there was nothing in the office.
No decision whatsoever that the NDPP has made that has to be, nothing on her table, so nothing to be filed in terms of any Rule 53 record from the NDPP's office. If there's anything, it will then emanate from, the other offices, the DPPs and the special director.
Now, prior to the judgment in the DA matter, where this issue of records, what was your approach in respect of what should be contained in a Rule 53 record?
Look, I'm very jealous with the information of the institution, especially where matters are still being investigated. It's very problematic. That's why I don't even like, going to discuss cases out there in the open where matters have not been finalized in courts. With a person, there's a potential accused, there's a potential suspect here. I don't like that. So I would not advise the NPA to provide a docket at a stage when it is not ripe to do so.
That would apply to a docket, confidential information, memoranda, and
Indeed,
internal documents.
the notes that are confidential sent to the NDPP around the strategies of the case. Because what is the point then? We might just as well not even lock our offices. Why do we encrypt some emails? Why do we have passwords? Then it would not make sense for us to do that. So I would not advise NPA to, disclose at an inappropriate time. And even what is disclosed, it must be something that I was comfortable with, that it's not going to prejudice the investigations or the prosecution.
Right, so we know that the DA case came and
Yes.
that ambit got expanded pursuant to that case. But in respect of the compilation of the Rule 53 record, both in the full matter and the poison matter, you didn't render any advice in respect thereof, did you?
No, I did not.
Okay. When it came to the appointment of counsel in the full matter, let's just deal with that quickly. You were present at the initial consultation with Advocate Motomela and his team, correct?
Yes. Mutimele, yes.
Motomele. To the best of your recollection, was the issues of the Rule 53 record discussed at that consultation?
Not at all.
Advocate Motomele subsequently provided a memorandum. Were you privy to that memorandum?
No, I was shown that memo. I don't remember seeing it.
Just to be specific, you were shown that memo by us.
Yes.
Right. Also present at that meeting with Advocate Motomela was Mr. Chita, and it was held in Advocate Jiba's boardroom, and she was present.
Yes, and I think there was a state attorney as well. I'm not sure what.
Okay.
Was it Isaac Chowe, maybe?
Oh. Could be. I would need to go back and check, but it's
Yeah, well,
either Mr. Chowe
the
or...
minutes, will
Yeah.
show, yeah.
Right. Were you ever asked to provide a progress report on this matter?
No.
The Motomele team consisted of 2 juniors, 2 silks and a junior, correct?
Yes.
And they would be charged with dealing further with the matter. Would that be the approach?
Yes. This is a case where the Office of the NDPP has chosen to deal with the matter with outside counsel. So we are there to assist the NDPP in providing instructions to outside counsel with whatever the NDPP may then require. At that time, in my mind, there is nothing that the NDPP should worry about. As far as I'm concerned, her desk is clean, and the instructions that were then given to the Motomele team was that the matter is premature, to which they also, agreed, hence the dispatch of the letter. And yeah, so this is the team that will then take care of the matter to finality.
The matter is premature because it's still under investigation.
No, it's premature because it has not presented itself in the office of the NDPP. So insofar as the NDPP is concerned, the matter is premature. Again, for purposes of the layer of the special director, the matter is still premature in my mind, because what Advocate Mrwebi has said to me is that I'm still busy with this matter. I don't understand why there is this FUL application, because I have sent my prosecutor to go out there and look for this information so that I can reinstate the matter back onto the roll. So here is a FUL coming with this application already talking about. Yes, so yes, that's why.
I think in common legal parlance, it's not the exhaustion of the domestic remedies before you even go to court. Isn't that so?
Yes, it is so, because again, I still repeat that what the DPP, the decisions of the DPP in terms of the constitution is in terms of the law. It's not just process or just prosecution policy. It's in the law, it's in the constitution, that the office of the NDPP will then be the one charged with review decisions of the DPP's decisions. So if you have not afforded the NDPP that opportunity, then the matter is premature. And again, with the information that I had at hand, that this matter is still being dealt with in the office of the NDPP. It's not final. There hasn't been any withdrawal. It's a provisional withdrawal which happens in the normal course of events, that may be wrongly placed, removed from the roll. In my civil language, matter is removed from the roll, does not mean that I've abandoned my case against you. So it is in that context that I say the matter is premature.
Okay, and so we know that.
Sorry, can you get the lexicon correct? It is not a removal as you understand it in a civil matter, but a withdrawal in a criminal matter. Is that, we understand the difference?
Yes, I understand the difference. That is why I'm saying in my civil language, it will be tantamount to the matter being removed from the roll, as opposed to you have abandoned your suit against your opponent. So the Mdluli matter, Advocate Mrwebi finds it on the roll. It's not supposed to be there. There are various outstanding aspects. We don't enroll matters if we have not finished with our investigations. We don't want to enroll, then you get postponements to an extent that you now get stuck off the roll because you take out for purposes of investigation. You must place your matter once you're finished with your investigation. So this is a matter where investigations are not complete. And why are we going to court to be entertaining, these issues?
And so when you talk about the NDPP's review powers, you're talking about her review powers under Section 179 of the Constitution.
Indeed.
And that section contemplates that a review can be sought by a relevant person, or one that the NDPP considers to be relevant, correct?
Yes.
And would, in your mind, such a relevant person includes the prosecutors and the members of SABC involved in the investigation?
Well, it includes everyone in the country or anywhere in the world.
But a relevant person to a particular investigation would have to be somebody who's involved in the investigation. It can't just be the public
Well,
outside.
there's got to be a link, a nexus between the party bringing the consent to the NDPP with the case at hand, yes.
And so my question is, would
So
a
the
prosecutor
prosecutor would
and
also
SABC have
be-
that link?
Yes, the prosecutor would also be, but then I would also then view it as an internal process where the NDPP is being apprised of certain issues that are emanating from a case, which then the NDPP should then be allowed to deal with.
And would it lie within the NDPP's discretion as to whether she or he would deal with it?
No, unfortunately, the NDPP will have to deal with the matter and then make a determination as to where the matter will be going.
Okay, let me turn back to the chronology I was at. We now have two silks and a junior on brief, and you then provided with a draft affidavit prepared by Advocate Motomela. I'm now roughly at paragraph 53 of your affidavit,
Okay.
right? And that affidavit is then brought to you, correct? And
Yes.
then you make corrections on it.
Yes, I did.
And you have a very vivid recollection of when that occurred, correct?
Yeah, it was around the time when we had a conference jointly with the Department of Justice and the South African Police Services, Advocate Jiba, the DG, as well as Ria Pierre, were steering that conference where we were discussing strategies around dealing with certain cases as a collective.
And you sat in that conference working on this affidavit.
Yes, I did.
It's okay, we all do that. And then that affidavit was collected from you.
Yes.
By who?
It was sent, I sent for a messenger to come and collect the documents that are going to NPA because I think at the time I was not going to go back to the NPA's offices, I was going to go to SIU. And I arranged for the messenger to come and collect it for the office of the NDPP.
Now, the evidence before the inquiry or the information we have is that this document was then misfiled in your office and only emerged subsequently that this document then was found in files that your PA had misfiled. What is your comment on that?
Well, first of all, I wouldn't know that it was misfiled. And secondly, when I sent for the messenger to come and collect, it was for the office of the NDPP and not to go back to my office because then who will deal with it in my office? So I sent the messenger to come and collect it for the office of the NDPP. But then when I was shown this particular piece of evidence, I inquired from my PA as to whether this happened because I have to make sure that I'm quite certain that this did not happen, that perhaps maybe the messenger decided to send the documents to my office, but there was no misfiling, and there is no way that we can misfile. I've got the books in front of me here. These are incoming and outgoing books of those years, which record everything that comes in, everything that goes out, who has it been booked to, and what were the comments of the office relating to the matter. So there is no record of those documents having come back to my office.
Right, so let's just, while we're on your books, you keep a incoming diary effectively in your office,
Yes.
which either you or your PA enter any document that is brought to your office,
Yes,
correct?
yes.
And that covers documents that are hand-delivered and documents that come via email.
No. Emails, she would not do that.
So that's the deliveries that come in.
That's the deliveries that are coming. It's everything, including letters of request, everything that comes in, she will record it.
Okay. And you've double-checked those books and there's nothing in there for
Yes,
that?
we've double-checked the books and there is nothing.
So as far as you were concerned, you had worked on a draft, your comments on the draft were sent back to Advocate Jiba's office, and you were under the impression that there was now a path to be followed for the finalization of the affidavits.
Indeed.
Right. Were you kept abreast of the progress of that matter at that stage?
Well, I was handling it. I was correcting the affidavits. I'm sending them, so I'm not going to be asking for a progress report from anyone when I'm busy dealing with the matter. So afterwards, I didn't get any progress as to whether there has been any filing or not. But I'm comforted that there is a state attorney, there is Toby Lekrita to just monitor if those things are done. There are 2 silks and a very senior junior from the Pretoria Bar dealing with the matter.
You then only some considerable time later discover that the papers had not been filed in the matter and that Advocate Matau is now in brief, correct?
Yes.
Were you ever asked or somebody called you to say, but where is that draft?
No?
Right, so some time later you discovered that the papers had not been filed and Advocate Matau was now in brief.
Yes.
Did you at that stage have any idea how he came to be on brief?
I had no idea, and I was very surprised that the answering affidavits have not been filed, and this is 2013. We're talking about June 2013.
Was it ever indicated to you that there was a problem with Advocate Motomela's answering affidavit?
No? Not at all.
Were you ever informed that the supplementary founding affidavit had been provided in the matter at that stage?
Before the answering affidavit,
look at teams and say, yes, they haven't been here long enough, they are not accustomed to the conditions, they haven't adapted properly.
right, Chairperson, it's page 52 of the annexures to my affidavit, which is page 52, NM7, part of NM7.
NM7 is the July one. I'm looking at the May one, which
It's right behind NM7, but
Dated 16 May.
it's been, sorry. It's been put into your evidence bundle, but copies were not.
What's the date on that,
52.
Mrs. Bell?
It's the 16th May 2013, and
It deals with the matter
of freedom under the law versus
It's on page
NDPP.
52
Yes,
of the file.
your files have been updated.
Yes, can I point out that it says page 52 and it follows my affidavit, but this was not an annexure to my affidavit.
No, it was
Yes,
not.
Yes, but I found it, it's right at the end, yes.
I understand my junior had handed it to the parties, a copy thereof. Right. Now, this memorandum was provided to us. In fact, to be correct, it came out of the documentation which was provided to Justice Yaqub, and that's where we got it. We will see that this is a memorandum which is from Mr. Chita to yourself and to Advocate Jiba, dated 16th May 2013. What is your comment on this memorandum?
First, I don't remember this memo. The second part is, it is saying the subject is the matter of freedom and law, and I have not ever asked for a progress report on this matter as I testified before. And when I saw this, I then also contacted Mr. Kita to give me the original if he has, because on page 57, Chairperson, the signature is not complete. Not that I authenticate people's signatures, but I've worked with Kita quite for a long time to know what his signature looks like. But this one, there are some breaks, and I was concerned about it. Hence, I called him to, if he can find, even from his computer, perhaps what would be a draft that he printed this memo from, and I didn't get it from him up to the time I deposed to an affidavit. But then this memo would not make sense, because the events that are talked about here, some of them I'm not privy to, and I'm still maintaining I didn't even know about the briefing of other counsel in the matter. So I didn't even bother to talk about the contents of this memo in my affidavit, because I'm questioning, firstly, the authenticity of this document. I inquired from who is supposed to be the author, and I could not find anything from him, and I don't know what to do with this, but even the contents are telling me that this is not a memo I would have, called for or even received.
And what about the style?
Look, this one is wow. Let me check. There are documents which have been presented to me, Chairperson, where I picked up that the font used is not the proper font that we would use, the size. If you look at is this the one or the one of the 25th of July?
I think we'll get to the
Yes.
25th of July.
But then this one, Chairperson, as I'm saying, I have not received this, and I have not asked for any progress, and even the contents of the this memo, some of the things I don't know about, and I question the authenticity of this memo.
But
So-
you accept that you might have been included in the chain and it could have been provided directly to Advocate Jiba without coming to you?
It could happen, but I don't want to speculate, but then I can't speculate if even Advocate Jiba had received this. And to my mind, if Advocate Jiba was working very closely with Kita around this matter, why would she be asking for a memo, a progress report, and when she's actively involved in the matter? That's what doesn't make sense to me, but I cannot rule out that it was sent to her.
And you say so because Advocate Chita would not have had the authority to brief, debrief, or set up consultations with
There is
council.
no way. Even I don't have the authority. I have to get the approval from the finance office that yes, this brief can go out, because they have to check if there are finances for that. So we didn't have a budget for NPA. The budget is managed at the finance office. So that is why there's got to be a signature of the CEO in approvals of anything that will attract any finances on the part of NPA.
So there would have been a chain of command, either Mr. Chita to you, to the finance person, with an instruction to then brief, or Mr. Chita to the acting NDPP, to the finance person to be briefed.
Yes,
Correct?
it will have to come from Krita, and then if my signature is not there, it's got to be a person higher than Krita who is authorized to pen the signature there too. If it's not me, maybe one of the DNDPPs, if I'm not present and it's an urgent something, I would get a call from the DNDPP. There's this thing on my table, should I sign it? Yes, continue, sign it. And then it will then go to the NDPP, especially if it is a matter that involves the NDPP, and then finally to the office of the CEO for the finance approval. Then it will then go out as the assurance, even to the state attorney, that yes, we will then pay for council's fees.
Right, so you then became aware that Advocate Matau was on brief with a different set of juniors to replace Advocate Motomela and his team, and answering affidavits had to be finalized, correct?
Yes, to my mind, at the time Mutau is on board, it is the Mutemele team that was briefed, as far as I know. Anyone in between, if there was any, I don't have any knowledge about. So yes, I then become aware there's Mutau on brief. The answering affidavits are almost, actually they were out of time. Because according to Mutau, we were supposed to file by the 24th of June, and we are still receiving a draft from Advocate Mrwebi on the 25th of June, which is a Tuesday, and then we worked on them just so that we can, at least file closest to the time. We're thinking, let us also do a condonation, because firstly we are late, and we have to also file a condonation for the late filing. Now,
So let me take you a step back. You were acquainted with Advocate Matau, you knew him.
yes,
And during that period, you then started working on this draft,
yes,
right? And you communicated with him during that process,
indeed.
right? And you, in particular, asked Advocate Chita to set out a timeline for you to sort out how you would be able to get condonation.
Yes, especially with the delays that emanate now from the previous year to
Right.
this year that we find ourselves in without filing any answering affidavits, because then I was not actively involved in the matter. If there's anything, he should then know.
Right, and you explain in paragraph 58 that the explanations given are unsatisfactory. You figured that you won't get a condemnation, and then you try and pick it up from the time Advocate Matau's briefed, and you ask Advocate Chita to do that timeline, which is attached to your founding affidavit as NM4.
Yes, it's the gaps of the silence that were unsatisfactory, not his explanation. He gave me a blow-by-blow account, but then there would be months unaccounted for, various days unaccounted for. So for a condonation, really, you need to give more to an affidavit to persuade the judge to give you the condonation. So it was problematic, because then there was no explanation as to the lull between 2012 and June 2013. And then again, as at the time Mutau was briefed, let's look at it from this point onwards, at least to try and craft a condonation affidavit. It didn't pass, so I chose let's abandon it and brave the wrath of the court for late filing, but let's just file then.
And the plan was to then file the affidavit as close to the date of the 24th as possible.
At least within the week, hence we were not even, knocking off, I would say. Yes, we were working through the days, the nights, from the 25th up to the early the 27th.
So let's take that. If you look at paragraph 59 of your affidavit, it starts off with Advocate Matau providing a draft answering affidavit under cover of an email, and that comes in late on a Friday night, so it doesn't reach you, correct?
Yes, it actually went to SIU's offices, and the time, I think it was 7:03,
Yeah, the time on the email says
7:03.
7:03.
Friday the 21st of June. And the filing is supposed to be the Monday, the 24th.
He actually asked for a response to the draft by the Sunday afternoon so that the affidavits could be finalized.
I was not aware at the time that there was firstly the draft that was sent to my SIU office via my PA at 7 o'clock at night. And I wasn't aware that we had to work on something to give anything back to Mutau by Sunday. And at that time, I'm not even aware he's on brief. Yes.
And in fact, you then informed of this, and you start working on this around the 24th, 25th, I think, and you get a draft response back from Advocate Mrwebi on the 25th.
Yes, there's a draft affidavit that was sent through from a Gmail address.
Ms. Mokhatla, you must be getting tired.
This is the convenient time, yes.
No, I don't know. I'm just saying your voice is going down.
It's going
I don't know whether
down.
Try to speak
I'm
up.
facing that way, yes, yes. Sorry about that, Chairperson. We were on the 21st.
Yes, I want you to just take NM4 out and keep it one side while we go through your affidavit, because this is the chronology which Advocate Cheetah prepared for you at the time, and his account of those days. So not all of it would necessarily fall, but it might just be an easy way for the inquiry to keep track on it. When he talks about the Friday, he's referring to the 21st.
Indeed.
Right. When he talks about the Sunday, he's talking about a call which he then made to you about the affidavit, correct?
You're talking about NM4 now,
I'm talking about NM4.
the Sunday. It is Tobile who's saying he received a call from the state attorney
Okay,
asking if he, Tobile, has
okay,
received
sorry, yeah.
the affidavit, not me.
And then on the Monday, he finds the affidavit from counsel indicating that they required input, and he alerts you to it. So you become alerted to it on the Monday, and you and he work with the affidavit. Correct?
Yes.
You then get instructions from Advocate Jiba with regard to the format, and this is consistent with your advice that she should depose to a affidavit of lesser content than what Advocate Mrwebi should do, because she's not the main decision maker. Correct?
Can I get you again?
That the path of action that you then follow is to prepare 3 separate affidavits.
Yes, that was my stance from the beginning, so I did not have to, it was understood. It was not a fresh instruction that Advocate Jiba says, I want it this way. It was always a given, because that's what we had discussed, from the previous year.
Yes. But Mr. Cheetah details in his chronology that in that afternoon, the ANDPP gave further instructions with regards to the format of the affidavits.
That's what he is saying.
Saying,
It's
right.
not me, yes.
And that Advocate Mrwebi was to depose to the main affidavit, right? So initially you compiled and finished her affidavit, and as you correctly pointed out, Advocate Mrwebi was on leave at the time, so you were not able to finish his affidavit on the 24th.
No, we could not, because we only got his draft affidavit on the 25th, the evening. I think it was around 4 p.m. or so.
Right. You then,
And I think he had in fact come to the office, I think it was the following day, I don't remember now as to which day he came back to the office, but then we could not finish that day and he went home. So we worked on, some of the things that were then required by council, including the records of the disciplinary, everything that Advocate Motau, required from us, more so because he felt that the state attorney had not briefed him properly. He couldn't make head or tail of the documents that were given to him. So in that process, we're also trying to make sure that council does get what, they need for purposes of fulfilling the brief.
right,
Ms.
so,
Bawa, can we use this opportunity to take a break? The recorders need a break of, 10 minutes? 10 minutes, thank you. We'll adjourn for 10 minutes.